in R&D to come up with a standardized technology. And this standardization has really offered India the economies of scale. 1 billion connections more than 1 billion connections as we speak. India is second largest in the world in terms of mobile telephony and fourth largest across the Asian market in terms of mobile infrastructure. We've reached here. You are sitting here in India, tomorrow you are in Japan, or you are trying to download a movie, the server of which is hosted in Kentucky. You are having an Airtel as a operator and you want to call up a friend who is using Vodafone. As a service provider, absolutely we find no trouble. There is no interoperability issue. There is no performance issue. And this is the value of a standard that we are talking about. This is the value of a technology that companies, or the few handful of companies that are now left, that we can actually count on our fingers, who have created best of the technology for all of us as consumers to use. What is the fight then? Why are we fighting? Why are we in the court? One of the reasons, as I said, that it's emotion versus a logic. Emotional pitch is never bad to speak or use, but it is absolutely bad to speak when somebody wants to delay the royalty payments or do not want to really come across the negotiation table and pay up. And why is that so? Why people don't want to pay? Because again, if you really look at the manufacturing size here, there are two sets of people. One is the technology provider, the other is the only user of this technology. Hardly there is any investment in R&D. These are the new manufacturing units which have just opened up. More than manufacturing units, they are more the assemblers of these phones. So 80% of the phones that we carry in our hands is rather imported into the country. And I would rather agree with what Deepak just mentioned, that this leads to unwillingness, because there is no downside for the unwilling licensee to really come forward and negotiate. And the reasons are three. Number one, okay, patentee, you have put in a lot of cost. First of all, let them prosecute at the patent office. Let it take 4 to 5 years for the patent to get granted. Let's go through it. Then when they come to me, I'll make sure that they pant to an extent and breathe like a dog that will never show up whenever they call up. And even after that happens, they'll arm twist the patentee to an extent that he will be lured to go to the court and seek a relief. Okay, now we are in the court and we are defendant and the plaintiff fighting. It will take number of years, as Deepak and Sanjeev just mentioned. And even after, at the end of the day, after many, many years, if court decide not in favor of implementer and rather in the favor of a patentee, he will end up paying the same amount he should have paid many, many years ago. So there is no downside. For good 10 years, he has, have the interest, he has gained the market power, he has received the entire business, so there is no downside really. And second is the IP here in terms of essential patent. It's not like a vending machine where you put a money only, then you can take a product. It's an open garment store. You go inside, take a technology, go out, walk out, and nobody can really stop you, because the entire recipe to make a mobile phone or a chip or a technology is all available right on the SDO's website. You don't have to really go to the patentee and ask for a technology transfer. Whatever you need, it's all made available by the patentee up on the web right on the day one. I won't take much time because you know what court cases are happening and where we are, but I will just end by saying, I don't know how many of you have read biology during your schools, but there is an importance of earthworms. Earthworms are the system engineers. They are the ones who bring a lot of nutrients, who keep the nutrients of a soil intact. And if I can safely quote these technology providers as the earthworms, they are the ones who have brought in the soul in the mobile phone. And unless they are there, you cannot see plants grow and trees grow, which is where we have Indian companies who were plants or seeds once, but they have grown up to a tree. And as a consumer, we won't be able to see the fruits as mobile phone unless we keep the entire ecosystem intact. So all I'm saying that I'm not against implementers or against or in favor of patentees. All I'm in favor of a balance, where patents are not kept close to my chest at any point in the day. At least come forward and negotiate. Thanks.
Thank you for that, Sheetal. And let me just, I will summarize very briefly some of the United States or North American perspective, and then we'll drill down on some of these issues across our panel. But in the United States, Our patent law, of course, is embedded in our U.S. Constitution. It's right there in our first article of our American Constitution that patent owners one of the important functions of the patent system is to promote innovation, and that patent owners, in exchange for publishing their information, have the power to exclude others. So that power of exclusion is in our Constitution. The patent system to protect innovation and spawn innovation is in our Constitution. And one of the issues that we're dealing with in the United States is the balance between patent law and antitrust law, or as you call it, competition law, or as some parts call it, monopoly law. And the biggest occurrence in the United States, if I had to pinpoint a couple of key issues or trends in the United States, one is this identification of these two competing issues, patent law and competition law. And this is regulated in America by the agencies, the Federal Trade Commission and our Department of Justice. And there's a specific set of guidelines that those two bodies of our U.S. government put out. And the last time they put these guidelines out was in 1995, and they are referred to as the Antitrust Guidelines for Licensing Intellectual Property. They came out in 1995 before anyone even talked about standard essential patents. And so they've been on the table this past year. So the current issue in the United States is what is these two commissions, or the Federal Trade Commission and the Department of Justice, what are they going to do about these guidelines for licensing? And are they going to modify the guidelines to address the standard essential patent questions that have been raised globally? Well, they've just put out in August of this past year, in 2016, a draft set of guidelines for updates to the 1995 guidelines. And in those most recent draft from the Department of Justice and the Federal Trade Commission, they did not specify anything about standard essential patents or FRAN licensing. They left it completely off the table. I personally think that's a good thing. I think it's good because standard essential patents and the rights that are associated with them really aren't different from other patents. And everything is associated with intellectual property rights is about negotiation. It's negotiation of the innovators with the standard setting organizations. It's negotiation of the innovators with the implementers, and so forth. So we don't really, in my opinion, need special rules to deal with SEPs, and I think that's reflected in this most recent set of proposed updates to the FTC and DOJ, Department of Justice guidelines. So that's the hot off the press information. Another trend in the United States that's really significant, I think, is that for the first time in 10 years, we've been seeing a pendulum move in favor of strengthening IPR. We're seeing more expansive rights in terms of what is patent eligible. Computer implemented inventions, for example, are now swinging back to where there's more favorable treatment in the patent office. So we're seeing better drafted patent applications focused on computer implemented inventions, and biologic inventions are finding their way now through the patent office again, which they had been stopped for, our famous cases of Alice and Myriad and so forth. So that's a good thing. The last big trend that I'll refer to is, of course, the changing administration. In a very short period of time, another week, we're going to have a new president. There's no question about it. We're going to see changes in our administration of the patent system. And those changes are going to impact directly on what comes out of the patent office, the quality of the patents that are issued, the processes that are addressed within the patent office, such as post-grant proceedings and so forth, the quality of those proceedings, the interaction of the U.S. Patent Office with the courts, the appropriate amount of oversight between the two. We've seen, I think, with the past administration, some attention to patent quality, but in my opinion, not nearly enough. And I think that with a greater focus on innovation, technology, and so forth, and the meaning of what it costs to innovate, with more recognition of as Sheetal was saying, there's so much investment in technology, so much investment, and courts and many in the public don't realize, who are outside of the innovators space, they don't understand how much cost goes into innovation. There's trial and errors, there's products that never make it to market. That doesn't find its way into damage calculations, but it's an incredible expense on the innovators. So I think we are going to see with a new administration, like it or not, you may like the Trump administration, you may not, but I think one good thing that will come out of the administration is more attention to quality of patents and a continuing trend toward protection of innovation within the United States, which should then make it easier for exchange of technology through licensing activity when you don't have to question the validity or integrity of the IPR. So that's a snapshot of some of the US issues. I think now what we'd like to do is turn to some specific issues on SEP FRAND, since we have a really fantastic panel here, and as you've witnessed now, very knowledgeable panel. We did have, as our first topic, just talking about the pros and cons of standardization, because some people believe that standardization maybe isn't a good thing, and others do. She'd already addressed that, so I think to some great extent the incredible value that standardization brings. So I think to address my colleagues' insightful comment, we're going to move to a more substantive issue of royalty-based issues. And of course, one of the big issues is component versus device, and what is the appropriate royalty base. I'm going to ask Sanjeev, if you wouldn't mind, to lead us off in this conversation, and then I'll ask the rest of the panel to weigh in on that one.
Thank you, Patrick. And this is an interesting issue. In fact, what Deepak and Sheetal said, and what Stephen also brought this to the fore, essentially it comes to the FRAND terms, the reasonable rate of the royalty, if you look at that. Because even what the courts in India or courts in US or the UK or the European court have tried to address, including the antitrust bodies or the competition body, they have tried to ascertain the reasonable rate of royalty. But what is the root, where is the root of all this? Let us understand firstly in the 3-4 sentences, what is a standard essential patent? There is nothing called a standard essential patent. These are essential patents, and when a patent becomes essential, let us try to understand this fact. When an innovator company they came across certain innovation, certain patents, which they believe could be potentially essential to a standard. So potentially, even they are not sure whether they are essential or not. They put those patents in the pool to the standard setting organization. When those patents are thrown in the pool as an essential standard patents, at that point of time, even the patentee is not aware that all the features of that patent will read over to the standard. Only in the subsequent the period of time, it may be considered as an essential to that standard. Now, thereafter, the bargain has to happen, and that is not a very smooth or easy process. It is a very complex process. And then there will be licenses, and there are certain terms between few implementers and the many implementers who might infringe. And then the matter goes to the court. In most of the cases, not only in India, but across the globe, what we have seen, either China, UK, Europe, or US, the court determination has always brought down the rate of royalty in relation to a particular portfolio of SAP or a singular SAP. In all the cases, the rate of royalty has been brought down substantially. In one of the Chinese case, the Interdigital, where the royalty rate was put by the Competition Commission was 0.019%. Then we need to understand whose role is the primary role, how one should ascertain whether it is the duty of the court to begin with, as Deepak said, how the innovator should chase the implementer. Sheetal mentioned it takes a hell lot of time to get a patent and then negotiate. At the same time, the innovator should have some incentive. There should be some incentive for the future R&D, future innovation, and in that context, in my personal opinion, the burden lies heavily on the innovators, some burden on the standard setting organization, to begin with when they are pouring the patents in the pool, to suggest these are the reasonable royalty for this. Because let us see the chain. You have innovator, you have a network player, and then you have implementers who are only simply purchasing or buying the chip or importing the chip to manufacture handset. So there are chip manufacturers, there are network players, there are handset manufacturers. A handset manufacturers or the manufacturers who only assembles the handset and they sell under their own brand. They may not be aware that what kind of patents goes into making those chips. So there is some kind of unawareness among certain category of implementer. Therefore, there is some burden lies upon the SSOs and the innovators to come out and publicize a reasonable rate of royalty which they believe should be most reasonable. Everything should not be left upon the arbitrator or courts to ascertain and devise, though it is a very complex process, but ultimately courts go through those complex process by the testimony of various witnesses, expert affidavits, and then ultimately they set down the reasonable rate of royalty based on those evidences. Why not this can be done beforehand, at least in those essential patents which are genuinely going in most of the chipset. Therefore, to sum up, what I would say is this: ascertaining a rate of reasonable, the FRAND terms is a very complex process. If the innovator wants the good incentive, reasonable incentive, if they are really interested in that, they should take the initial burden to come out. Don't leave everything for the implementer to come and negotiate and bargain hard. Their stand should be reasonable, and as Deepak suggested, the innovator is interested in selling those patents, licensing those patents, and not the enforcing through the courts. Probably that where we will see less court cases, more licensing, less infringement, and less intervention by the courts. And then, considering the Indian scenario, the courts then might not be inclined in those cases to issue ex parte or the interim injunction, but to ascertain actually the reasonable rate of royalty, reasonable rate of the royalty as published or as prescribed by the innovator. Thank you very much.
Thank you for that, Sanjeev. And could I ask you, Deepak, do you want to add to that?
It's difficult for me to, digest the issue of publish the royalty rates. When I sit down and negotiate in front of a prospective customer, I'm pretty sure that all of us would have gone to a market and bargained in Sarojini Nagar in Delhi. How many of you would have bargained in Sarojini Nagar in Delhi? Almost 50–60%. Let me, enumerate that in a very common sense. Let him be the, he is the seller. Okay, he is the seller, and let's say that I'm entering into the shop. He will say, 100 rupees, 100 rupees. I will say, no, 10 rupees. Fine. Then what I will do is I will see whether somebody else is standing next to me. Okay. And if somebody else is standing next to me, I will try to ask him, hey, whether you also want it, then I will bargain for you also together. If he sees that, okay, there is a possibility of selling it to two different people, okay, he will say, fine, I will give it to you 10 rupees, at 10 rupees plus, but don't inform to him. It's a very standard operation, I may get a preferential rate because of certain reasons which may be unique to me, but I do not have to always get, he does not have to give the same preferential rate to some, third party. So publicizing the royalty rates, therefore, in my personal opinion, is not so essential. I would say that just go by that there is a FRAND royalty rates which is available. There is a margin between the upper limit and the lower limit. As interested party, if you are asking as to what will be the royalty rate range, I will be more than happy to inform you about the royalty rate range on day one. That's all. And then afterward, let's sit down on the the desk and we will sit down and bargain. In one of the very specific instances which I was dealing with in terms of demerger, there was a huge portfolio of 34 products and a portfolio of close to 1,600 patents in India. The negotiation was happening between the top management, that is CFO level, between the two parties, and they never bothered as to what is the total number of patents involved. They just simply looked at the possibilities of royalty, what will be the break-even time, and things of that nature. CFOs don't understand patents at all. They are only looking at very simple issues. Okay, I have to give him 10 rupees, fine. When will I recover this 10 rupees if I do this? So actually, when the bargain is happening between, in that sense, they are not looking at whether there is a patent per se, whether out of the 1,600, which of them is going to be reading onto it, which of them doesn't read onto it. All these are, superfluous. So as a basket bargain is what generally the patentee tends to offer, that okay, here is a basket of what I believe you might be required to implement it as either as a standard, as an add-on, or everything. It's not simply a SEP per se. It's a total package deal. Take the package deal, sit down and negotiate on the price of it. It's as simple as that. If you go back into drilling the essentiality of it and things of that nature, you're just simply derailing the entire negotiation by at least couple of years, or even in a best case scenario 6 months. Because if I have to look at from a legalistic perspective, what will be the time that I would as a lawyer take to ascertain what is the essentiality of the bigger portfolio of 1,600, I can say easily nothing less than 6 months. So we are just simply negotiating or bargaining it out by more than 6 months. At least some of them will be still negotiable, essential. You will not say that nothing is non-essential. There will be at least 5 or 10 patents out of the entire basket which will be essential. Assume that you are just simply bargaining for those 10. As a part and parcel of that 10, you are getting the remaining as freebies for you. It's as simple as that. So get the 10 and remaining may be treated as freebies, but negotiate on the price side.
Yeah, I agree that, and as I said at the onset, negotiation is the key to all of this, I believe, but understanding how to negotiate is an important part of this whole process, and knowing, for example, what is the royalty base that you're working around, and that's one of the issues that we have grappled with in the United States.
Sorry, Patrick, could I take a minute in rebuttal? I'll take just a minute.
Well, I was going to...
Okay, you go.
I'll come back to you on a later issue. Save your point, though, because I'd like to focus on a look at the inside corporate perspective on this issue and just get a sense, Sheetal, how Ericsson, and I don't know if you're speaking for Ericsson, but I guess we want to say that all these comments are the comments of our panel members and not necessarily those of our firms or companies. But it would be interesting, I think, to hear your perspective. And then, Stefan, I'd like to hear what's happening in Europe on this issue of royalty base and component versus device. But Sheetal?
Well, I won't speak like an Ericsson. I'll just put my hat as a consumer and speak. I think when we have seen in India, and I've told you that it is not really, Sanjeev, an issue about, giving out a royalty chart as to how much do I need to say. The real issue is people do not want to pay. There is an unwillingness. Whether you publish your rates or you do not publish your rate, at the end of the day, you are not able to see unwilling licensees come even across the negotiation table and ask and get a mutual consensus done. So that's the real issue. We need to hit that unwillingness part first and then decide on to what should be the royalty rate, where I should publish, should I publish it on SDO website or not, is it a commercial discussion or not. So anyway, that's one thing. And secondly, I think your concern I very well appreciate if I really put my foot into the shoes of an implementer who doesn't know how much I'll be asked for. I think Delhi High Court has done a very good job already. They have given out an interim order saying that for a 4G compliant phone you have to pay $1 per the overall ASP of a phone, and otherwise it is 0.8%. So I think the rate is not an issue anymore after the interim orders have come out. It's only the unwillingness. Those who don't want to pay will not pay. Don't we see in our media entertainment industry, after 3 months, movie comes out free on TV, but we don't want to wait and we still pirate and we still download a movie. I think it's an inherent genetic makeup. We first need to change the mindset that if I'm using somebody's IP, let's at least go ahead and seek and proactively ask a license. That's one. Now coming back to what Patrick you actually mentioned, and you wanted us to address a question of a chip versus a phone and what should be the royalty base. For the audience, just to bring in a clarity, the debate in India is whether you can, as a patentee, ask for a royalty on a handset. So if it is being sold at a ASP of $150, should you be asking a royalty on this whole handset? Or should it be on a chip, which is a silicon that goes into the phone, which is only a home for the technology to rest? I will like to use a normal analogy of a pharmaceutical drug. Let's say there is a capsule, it has a pharmaceutical compound. So far that compound is in a capsule. Can you ever know what therapeutic value is it producing? So far the capsule, it remains a capsule on a table. Would you ever know what it is going to treat you as? Unless it goes into a body, attaches to a receptor and produce an effect. The issue that Patrick asked is exactly same. Here capsule is a chip. Compound inside that capsule, which is an active ingredient, is the technology. And the body of a human body, this body, is a mobile phone. Unless this chip goes inside into a phone, you can never know what is the value that the technology brings to all of us. And this is the only reason when you go in the market and you purchase a 2G basic phone and you get a 4G compliant phone, what do you pay for more? A 4G compliant phone or a basic phone? You pay more for a basic phone or a 4G compliant phone? A smartphone we pay for more, because the contribution of a technology you're able to see on a smartphone. Whether you can use your internet browsing, whether you can, even if this has 36 GB memory, and the other phone also has 36 GB memory, but one has a 2G, one has a 4G, you will definitely be ready to pay out more for a 4G phone, because now you can click your photos, put it in a storage, put it on an Instagram, use more internet quite often. So I think we should leave away the debate of whether a chip or a handset. We should only, I'm telling you, it's a wild goose chase. Implementer would always want a chipset because chip can be manufactured only in $2, so he'll say, okay, I'll give you some X amount on that $2 and not on a $150 phone. The only point is when you arrive at that FRAND figure, that amount what should be going to the patentee should only be decided basis the value or the contribution that technology is making. And that's the only thing. Whether you multiply a higher number with a smaller royalty base, meaning a chip, or you multiply a lesser number with a higher royalty base, finally you must arrive at a number that is directly proportional to the value that your technology is bringing. And that's the only thing that patentees are asking for. That's from my side.
Thanks, Sheetal. And Stefan, could I ask you for some perspective on royalty-based, royalty rate issues?
Yeah.
From
No,
Europe.
Let's summarize what I'm in the position that I'm not corporate, I'm an attorney. And I look at it more or less from the infringement or enforcement side. And the general message is, as was already said, royalty rate ultimately what you base it on, or whatever. It's a matter of negotiation, it's a matter of economics, and I strongly believe that in a good economy with balanced forces and partners negotiating at equal level, you will somehow end up with something that's truly reasonable. And of course, one of the reasons for the debate currently is that we are still in the economic process of finding a level of royalty somehow that is acceptable to all parties and on an economical scale is reasonable. And we have some new players now. Automotive industry is coming in suddenly. This opens new dynamics. I think this is simply an open process that ultimately will result in some practice that is widely accepted. So but looking at from the attorney side, first the case law is very clear, and that addresses what Sheetal said. If there is an unwilling licensee that does not really truly come to the table, that drags out negotiations, that's clear. The full force of the law should come upon this person. There should be an injunction. That's fairly clearly established. But what are you going to do with cases that happen? You have, let's say, Microsoft versus Motorola, Samsung versus Apple, neither of which are professional people who know what licensing is about, and I would guess that the receiving side in these disputes was not exactly unwilling. Still, there is a dispute on the level of the royalties, and the development of the case law and the discussions we had is that the German courts at least have learned, whereas at the beginning they said we should be able to pinpoint and fix the number they meanwhile throw up their hands and say, we cannot determine what a reasonable royalty is. We cannot say whether $1 or $5 is right or anything else. So please, in a way, that's something we cannot decide, and some judges even say we don't want to have this question in our court. What is now emerging, what the courts say we can do what we have learned, what we're doing all the time. We can apply legal criteria to what is going to happen here. So you bring your proposals, your negotiation process to us, and we'll look whether we see a discriminating behavior or a delaying behavior, and then we can decide, well, did you make a true friend offer? Is, in case of a willing licensee, did the other side make a true friend offer? And then we can decide under legal terms that we will grant an injunction or not. Now, is this the proper solution? And we have a saying among legal scholars in Germany when somebody comes to the judge and says, I want justice. The judge responds, you will not get justice here, you will get a decision. Meaning, now that's the continental coded law view of things. Of course, Americans would take a different view. But the upshot is, when you take things to court, you will get a decision, and you may not like it. Neither party may not like it. And especially if it comes to the point where the judges really need to review the whole negotiation process and to assess which party behaved properly, which party behaved improperly, always assuming basic willingness, then I feel that this will be a problem for the future, and this is on longer-term scale not manageable. Possibly to promote the process, but long-term not.